Okay, so that's 2 minutes past. In interest of time, we will start the webinar. So a massive thank you for joining us today at this disclosure focused webinar. It's lovely to have you with us. I'll start off with a couple of intros if I may. So for those who don't know me, my name's Esther Burrell and I'm a Claims Relationship Manager here at Zurich. In terms of hosting the event today, I've also got Lisa Maynard and Dan Whiffin joining me from Zurich. I'm also delighted to have a couple of guest speakers from Zurich joining us today. We've got Alison Whittington, Head of Housing, and Ella Baker, Casualty Team Manager, who'll be joining us for the Q&A session. And last but not least, we've got Rachel Fawcett from Waitmans, who'll be taking us through the main presentation today. So just a quick bit of housekeeping before we kick off. Your cameras are off, your mics are muted, but the Q&A facility is enabled, so please do use that functionality as you go through the presentation. And in terms of takeaways from the event, we will be sharing the recording afterwards. So without further ado, I will hand over to Alison Whittington, Head of Housing. Thanks, Alison.
Thank you, Esther. Great introduction. I just need to live up to that and continue. Good afternoon, everybody. It is lovely to have you join us. For those of you who I don't know, my name's Alison Whittington. As Esther said, I'm Head of Housing for Zurich Municipal. That means I have accountability and responsibility for the end-to-end provision of insurance to housing associations within Zurich in the UK. I know a number of you, so lovely that you're joining us today. For those of you that I don't know yet, great to virtually meet you. I'd just like to start by thanking Rachel for joining us and sharing her expertise. There's a real bargain, I think, when it comes to setting up a lunch and learn. The attendees provide their own lunch, and the hosts provide the learning. So I know with Rachel, I think we've really kept up our end of the bargain, and I hope your lunches are good enough so you're happy with your end. As Esther said, Rachel will be taking the majority of the time with her presentation, but then there is definitely going to be some time left for questions and answers at the end. So as you're munching on your sandwiches, noting down the questions, we'll make that a really good, lively, interactive part of the session. A little bit of background to this event, I think, because as to why we've put it on. We've seen within the press, within the industry, within sector-wide, a real increase on the conversations around housing conditions. The regulator regularly talks about it, the press regularly talk about it, boards regularly discuss it, exec teams regularly, throughout the sector, both the housing association sector and local authorities. It is a real hot topic. And as you'd expect, we've seen a significant increase in the injury claims that we see coming in, arising from these conversations and current housing conditions. We've listened to you, and you have told us that the disclosure part of those claims can be a really tricky one to navigate. How do you hit that Goldilocks band where you give us just the right amount of information, not too much, not too little, the right amount and of the right type? And that's what we're going to be talking about how that information comes to our claims handlers. And actually some of the consequential difficulties that the wrong information or too early, too late, whatever, can make for getting to those liability decisions. And getting to those liability decisions really important to enable us to progress claims in a timely manner. We've got 4 objectives for this event. We are looking to give you an overview of the claims process with that focus on disclosure of documentation, what requirements there are for that disclosure, what you need to give us, what documents should be provided, why, and what timescales. Want to give you the context and the overview to really bring it to life. And then really importantly, this is a really grey area, but some guidance on the difference between a complaint and a claim, making it a little bit easier for that issue to be navigated. So that's enough for me. That's the introduction. I will hand over to Rachel to take you through the content I've just described. Thank you, Rachel.
Thanks, Alison. Thanks for the introduction. Many of you might have already had the opportunity to speak to me in some sort of guise in the past. For those of you that don't know me, I'm Rachel Fawcett. I'm a partner at Waitmans, and I also head up our housing claims technical unit. So for the vast part of the last 10 years, I have dealt with claims made against public sector organisations, predominantly local authorities, and I've really had a focus on housing. So that's housing claims that arise from your defective premises type claims, occupiers liability, sometimes data protection related claims, and also more commonly in recent years, injury claims and illness claims arising from damp and mould. As Alison said, this session really has come about from what is being said by you, the customers, in terms of just navigating that disclosure exercise. So I'm hoping today we'll be able to sort of go back to basics and provide some information in regards to the duty and requirement of disclosure, and then some top tips as we go through to help you navigate that process and be able to really maximise what you can get from that and really understand what the process is and how you can help navigate that claims process as well. So the agenda today, we're going to look at the requirement and duty of disclosure. There's a lot of legalese there, but I will try and navigate that with you. What you need to be sending to insurers or panel solicitors when a claim is made, why those documents are needed and why they're important, and the timescales and some top tips. And as Alison said, just having a quick look at complaints versus claims and some information there to help you navigate that as well. So let's crack on. So looking at the requirement and duty of disclosure, lots of you will be asked for documentation, but actually, why is that needed? What are the requirements? What are the duties there? Well, the purpose of disclosure really is twofold. Firstly, it's to make available evidence which either supports or undermines the respective parties' cases. And it's for the court to do justice between the parties with an all cards on the table approach. So that duty of disclosure continues throughout the lifetime of a claim, but there really are two key elements of a claim lifespan where disclosure takes place, and that's what we're going to focus on for the first part of this session. So that's looking at pre-action disclosure, so that's your initial disclosure when a claim is made, and then standard disclosure, so that's during the litigation process, so once court proceedings have been commenced. So let's take a step looking at pre-action disclosure. As I said, there is a lot of legalese here. I am going to try and break it down for those of you that perhaps have never quite delved below actually what disclosure really means and where those requirements come from. So pre-action disclosure is the process by which disclosure is given by a party at a pre-litigation stage. So this is when the claim is first made. So generally, such disclosure will be given when formally responding to the claim. So that will be the letter of claim or the claims notification form, and particularly when denying liability. Now, that's not to say that there wouldn't be disclosure documentation when there's going to be an admission in the claim, but more often than not, that disclosure is provided to the other side when there's a denial, whether in whole or in part of liability. Now, before we get to that point, obviously, you've got to provide that documentation to the insurer or the panel solicitor or whoever is dealing with that claim from inception. So even though it might be a claim to admit, that documentation gathering still happens in the background. It might just be that it doesn't go any further and doesn't get provided to the other side. So where do the requirements come from and what can we really find out in terms of what's needed and what that duty is? So lots of the information we find are in what we call pre-action protocols, and there's four that really affect housing type claims. So this is your defective premises, occupiers liability, injury, accident claims, and also your housing conditions claims with and without an injury element as well. So I've listed the four relevant pre-action protocols on this page, and it might not mean anything to some of you. Some of you may have seen reference to them. I'm going to focus on two, just to give some more information. There's a huge amount of information on this slide, but don't worry, I will run through it. So the first one is the pre-action protocol for personal injury claims. Now, this will be relevant for your defective premises, accident, injury type claims. So let's park housing conditions for now. This will apply where even if there's been a claims notification form submitted through the portal, if liability is denied, this protocol is triggered. So this is really one of the ones that's a real key protocol in these type of claims. Now, what does the protocol actually say, and can we sort of pick out some key parts there? So I've put the real key information on this slide, but let's just run through it. So the protocol says that the aim of early disclosure of documents by the defendant is not to encourage fishing expeditions by the claimant, but to promote an early exchange of relevant information to help in clarifying or resolving the issues in dispute. The claimant solicitors can assist by identifying in the letter of claim or in a subsequent letter the particular categories of documents which they consider are relevant and why, with a brief explanation of their relevance if necessary. And then going beyond that, actually, this is particularly unhelpful from a housing perspective, but I've included it for reference anyway. There is an annex to this pre-action protocol that sets out specimen but non-exhaustive lists of documents that are likely to be material in certain cases. Now, that's particularly helpful if you're dealing with, say, a high-wage tripping claim or an employer's liability claim. But unhelpfully, from a housing perspective, there is no specimen list for housing claims. So this is where the difficulty comes for yourselves, because there isn't a list telling you actually what should be provided in any particular case. So we have to really then look at the bigger picture, and that's what I'm hoping to be able to do with you today. So pre-action disclosure. So this is the first stage of disclosure, and this is actually the process whereby documents are given to the other side. But as I said earlier, this really starts with you gathering those documents and providing them to the insurer or solicitor from the beginning. So pre-action disclosure is generally limited to the documents required to be enclosed with any letter of response. And in cases where liability is admitted in full, as I've already said, those documents are going to be limited, and that will be to the quantum element of the case. So that might be, for example, an accident report or communications that refer to an accident, some details that might be around the injuries that someone said they've sustained, or how long they might have taken to recover from those. They might be really relevant to the compensatory aspect of the claim. So there might be some documents that you hold that are still relevant, and they should be provided early doors anyway, because obviously they're going to help make that liability decision as well. Beyond that, if both of the parties or either of the parties consider that there's issues with disclosure, but there's a disagreement about some aspects of that process, there is recourse to the court available to seek an order for the party to provide disclosure. Now, we most commonly see this where claimant solicitors will apply to the court and make an application seeking an order from the court to say that the defendant, so yourselves, provide set number of documents by a set date. And we'll go into that in a little bit more detail in a minute. So just having a look at the pre-action protocol for housing conditions claims, this is a bit more helpful in respect of providing some detail as to documents to be provided in such claims. Now, this protocol does encompass some element of an injury and illness claim, but most will fall outside of this and go to the protocol that I've just discussed. But the general liability documents would still be the same. So this pre-action protocol sets out that the letter of claim, so this is the letter of claim from the claimant solicitors, should request disclosure from the landlord of all documents relevant to the poor housing conditions, which would include a copy of the tenancy agreement, including any tenancy conditions, the tenancy file, any documents relating to notice of poor housing conditions given, including copies of any notes of meetings or oral discussions, any inspection reports or documents relating to works required to the property, and any computerized records. So a much more helpful list to be able to work towards there. So documents relating to rent arrears or other tenancy issues will not normally be relevant, certainly at this stage, but there's nothing in the protocol that restricts the right of the tenant to look personally at their file or request a copy of their whole file. And neither, again, is there any issue with the landlord sending a copy of the whole tenancy file as well. So a bit more helpful in terms of those housing conditions claims, but I think we can lift some of the documents that are there and apply them to claims more generally as well, and we'll cover a list of what I consider is the general documents that should be provided for all housing claims shortly. So jumping back to that pre-action disclosure that I was talking about previously, I mentioned that there is recourse available to the court to get an order to compel one party to provide disclosure of documents. It is most commonly seen, as I said, by claimant solicitors making these applications, but that doesn't mean that we can't make the applications the other way around, and they're just less common. So there are a number of situations and scenarios in which a pre-action disagreement could arise and could result in an application for pre-action disclosure. Most commonly, they are a failure to respond to the letter of claim or claims notification form at all, a failure to respond on liability or provide disclosure within the relevant protocol period, and we'll cover those timeframes in a little while. Responding on liability but providing no documents, and or responding on liability but providing inadequate disclosure. So there's a number of reasons there that could give rise to the claimant solicitors deciding to make an application. So a failure to deal with the issue of documents does allow that application to the court compelling an order. Now, sometimes the court will deal with those on paper and will just simply serve an order requiring disclosure of a set number of documents that are normally listed to be provided by a set date, and costs are normally payable as well. So they are generally cost-bearing applications. Sometimes they will be listed for a hearing, and there is no rhyme and reason. There are some nuances in different courts, but generally those applications will in part be successful. And as I said, they will be cost bearing. So there is a real benefit of knowing what documents to provide to the insurer and panel solicitor early to try and avoid these applications being made. And they can be quite time consuming to deal with, both from your perspective and whoever's handling them for you. And also just sort of detracts from actually being able to deal with the key issues of the claims process as well. So the second part of disclosure in the lifetime of a case is standard disclosure. So this is the process which happens during the litigation. So a claim has been made, a response has been provided, disclosure has been provided at that early stage. The claim is defended and does not settle. The next option for the claimant, if they want to pursue it, is to commence court proceedings. So they do so. A response is provided in response to that claim formally through the court. So that's your defence. And just after that, the court will give us a timetable. So there are directions as to the steps to be taken to lead for the matter being listed for a trial. So the first step in that timetable is disclosure. So this is what we refer to as standard disclosure. So standard disclosure requires parties to carry out a reasonable search for documents, bearing in mind all of the circumstances of the case, the value of the dispute, and the overriding objective. So there are some bits in there that might not necessarily make sense, but the key aspect is that it's a reasonable search. So just some key information that might be of assistance here. A document can include all media on which information is recorded. So it's not restricted to a Word document or a PDF or an Excel spreadsheet. It could be any document that has been created. And just in terms of a recap, really, just to understand the difference between disclosure and inspection. Disclosure is the method by which a party states that a document exists or has existed, and inspection then is the process by which the other party requests sight of that document. And I will run through the disclosure list a bit because I think there's some really key information there that people don't necessarily know, and I think it provides a real good background to disclosure generally. But when we provide that information for a list of documents that exist, that's just providing a list. It's the inspection process where the documents are actually sent to the other side. So standard disclosure requires a party to disclose only the documents on which they rely and documents which either adversely affect their own case, affect another party's case, or support another party's case, and the documents which are required to be disclosed by any relevant practice direction. So again, some of that might not necessarily make a huge amount of sense because there is some reference to practice directions, and that's really where those who deal with the legal aspect will know what's happening. But effectively what that is saying is that we can't sit on any documents that might not be helpful to the case. There is a requirement that all documents that are relevant to the issues are provided for disclosure. So it might be the fact that you could have a claim whereby perhaps a claimant has tripped on an estate pathway. It might be that that particular defect was picked up on an inspection before, but for some reason a repair wasn't undertaken. We can't just withhold that inspection record because it doesn't help the case. It has to be disclosed. Now, I'm sure that no one would try and do that, but it's just to make it really clear to the parties that that duty does include documents that might not necessarily be helpful to your case and might support another as well. So on the next couple of slides, I've got a copy of the standard disclosure list, which some of you may well have seen if you've dealt with cases that have litigated. And this disclosure list will be used in all civil cases. So this will be your housing conditions and any other housing accident type claim as well. And normally you'll see the likes of myself or another solicitor will send this across to you, all filled in and asking you to sign it. And sometimes you can not really understand exactly what that document is. Now, there are a lot of documents that solicitors can sign with your authority, but a disclosure list is not one of them. And the reason for that is the duty and requirement of disclosure really does sit with yourselves. That duty to undertake a reasonable and proportionate search for documents lies with the defendant or the organisation that the claim is being brought against, and not the solicitor. So whilst we can provide assistance by drafting the document and putting all the relevant information here, that duty really falls to yourselves to make sure that you are satisfied that you've complied with that duty. So I thought it'd be really useful to just run through this document. And I appreciate that there's quite a lot of information here on this document, but there is some really useful wording that I just want to draw your attention to. So this is the first page. And on the first long box that you can see at the top, it does require us to put a name and a position of the person that is signing it. That would likely be someone senior within the organisation. And it might be that they rely on yourself or someone else to have undertaken that search, but they do need to be satisfied that the disclosure obligations have been complied with. And it does go on to have a certification on the next page, which I'll run through, that sets that out as well. So on this page, it allows us to put restrictions as to the search of documents that have been undertaken. So you'll see that it has a section about a third of the way down that says, I did not search for documents. And then there's a number of boxes underneath. This allows us to limit a search up to a certain date. So we can say that we did not search for documents predating a date in the past. So that could, for instance, be 1 year pre-accident, 2 years pre-accident, 3 years pre-accident. There's going to be some case specific information there that would determine what that potential restriction is. Normally a year pre-accident is a good starting point. It allows us to set out where the documents were or were not searched for, and any categories as well. So for instance, if we had a matter where there was no issue on liability, we could set out there that categories other than quantum and causation were not searched for. So we're not including all of the liability documents there as well. There is an option obviously there to restrict, and it makes it very clear the extent of the search that's been undertaken. Now the large box at the bottom, that allows us to set out details about electronic documents and what searches have been undertaken. Now, this is most commonly undertaken for more higher value and complex matters. And I would say that you would ordinarily see this where there's perhaps a large number of emails or electronic documents that are being searched for across, for instance, a number of individuals' emails, a number of certain files where you might save stuff, different drives. And what that allows us to do is set out what the search terms were. So in the same way that you might search your emails for an email off, say myself, you can set out there exactly what you've searched. That could be a property address, it could be a claimant's name. So it allows us to really set out on that first page the extent of the disclosure exercise that's taken place. So that's the search, and being able to set out what those parameters are. So moving to the second page, this allows us to go further and actually set out which areas that we didn't look for. So you'll see that there's documents that are contained or created on PCs, database, backup tapes, etc. They're obviously going to be really relevant to your organisation. So for instance, you might not have anyone that uses PDA devices. There might not be any mobile phone usage where information could be stored. My view on this is the more valuable and complex the case, the more detailed the searches are, but you will know your systems best. Lots of the time they will be contained simply on PCs and databases. There might be some particular cases whereby you're having people go and do inspections and there's information stored on PDAs that need to be downloaded. From experience, they're normally downloaded and captured on your case management systems anyway. So it's really an opportunity for us to set out again the parameters of what that search was. Now, I think what's most important about this page, at the bottom, this is where we are requiring whoever has performed that duty of disclosure or who's signing the document to sign it. So this is the bottom of the second page. And above that, you will see that it says towards the bottom of this slide that I certify that I understand the duty of disclosure and to the best of my knowledge, I have carried out that duty. I further certify that the list of documents set out in or attached to this form is a complete list of all documents which are or have been in my control and which I am obliged under the order to disclose. So there is that certification there. So it is really important that whoever is signing that is satisfied that that reasonable search, which I referred to earlier, has been undertaken and all of the information set out as to the parameters of that search is correct. Now, moving to the final page, this is the one which you probably will spend the most time looking at. So this is where we would list all of the documents, and they're split out into 3 key areas. So the first section at the top of the form is effectively a list of all of the documents that we are prepared to provide disclosure and inspection of. So that's where we would list things like the tenancy agreement, repairs and maintenance records, photographs, inspection records, contact records, all of the documents that we are absolutely content for the other side to request a copy of and to have sight of. The second section of the form, which contains 2 boxes, is for us to be able to set out any documents that we do have but are not prepared to provide disclosure of and the reasons why. So a lot of this you will see will have very standard wording in, and it will cover things, for instance, like advices that we've given to your insurer or yourselves regarding the claim. Could be draft witness statements, attendance notes, file notes. There might be contact records for, say, a communal area that's got third-party information in that we may have redacted. So we may want to say that they can't have the original document because it's got that third-party sensitive information in. So we're able to list those documents there in categories or specifically if necessary and say why they're not being disclosed. Now, the usual reason is that they're subject to some form of privilege, and we will be able to deal with that as legal advisors. Now, privilege is a whole issue and a whole session in itself, which we won't cover today. But that is an opportunity if there's any documents that are sensitive or we wouldn't ordinarily disclose that we can set out there. And then finally, the very final box right at the bottom is one that I think is sometimes overlooked. So this is where we can set out documents that have existed, but for some reason don't anymore. So a classic example of this would be CCTV. Often claims are brought and there is perhaps CCTV in operation, but it's on a loop. And by the time the claim is notified, whatever footage might have been available has been overwritten. So that would be a classic example of something that had existed but doesn't anymore. And we can set out what that reason is. It might also be that there perhaps was handwritten notes from a housing officer following a meeting and they've been destroyed with their notepad. So there might be genuine documents that did exist that don't. So we are also obliged to set those out as well. So it's really useful from your perspective to know what documents could have existed early days so they can be made a note of as well to help later on in the process. So that's kind of looking really back to basics. And as I said, there's a lot of legalese there. I genuinely think that being able to understand the duty and requirements of disclosure is a really helpful process, even if it's just in basic terms, to really understand why am I being asked this, why is it important, and where does that fit into the process? Is it just the insurer or solicitor is being particularly difficult and wants all of this information, or is there actually a real reason behind there? And as you can see, there is a genuine real reason that's contained within all of the rules that we have to comply with in civil claims. So it is really important. It's not something that we're just asking because we fancy reading all of your repair records. And there is a real basis for that. So cutting through all of that, I've already said that unhelpfully, there's not a specimen list of documents unless it's a housing conditions claim as to what documents do you actually need to provide when a claim is made. So I've put together a list here of what documents I consider, from my experience, are documents that really should be provided initially. And there is a question there, do you provide everything? Do you provide nothing? Do you provide the kitchen sink? What is it and how much do we need to provide? So I'm going to go through this list with some information that I hope will be helpful. And I will deal with some top tips in terms of how to present those documents as well. So first and foremost, I consider that these documents should be provided across all housing claims. There will be some nuances where you think that's not necessarily relevant, depending on the specific facts. But generally speaking, the documents listed on this slide A to G are probably a good starting point for all claims, whether they're housing conditions or not. So first and foremost, tenancy agreement and any separate tenancy booklet and terms and conditions. Through all the housing organisations and local authorities that I've worked with, you all will have separate documents relating to the tenancy agreement. Sometimes it's one comprehensive document, sometimes it's across a number. You might have a really short form tenancy agreement that's got all the details of the tenant and the property and the rent, and all of the individual terms to do with repairs and maintenance, and all of those issues might be contained in a separate document. Really, we need to see both to see exactly what it is you're setting out is responsible of either yourself or the tenants. Really important for the likes of communal areas, outdoor areas as well. So there is a real importance of knowing all of the details there. Secondly, maintenance and repair records for the particular property, if the accident has been within the demised premises or communal area or estate. I've said they're not screenshots, and I will detail this in a little bit more information. So basically, the records shouldn't be limited to what you consider to be relevant in terms of maintenance and repair records. I think this is a really key issue. It's about looking at it holistically. I think there's a real focus on looking at exactly what the potential cause of an accident was. So it could be a raised flagstone or an issue with some communal steps. I'm really focusing in on that issue. So we're just going to look at all reports that were made regarding flagstones or all reports that relate to steps, and actually almost like deleting or redacting out the other information. And we ask that you don't do that. The information is really useful for a number of reasons, and we can see how often people are calling up to report other issues. It gives us a bit of a flavour of the property generally. And also for individual property, if you've got a tenant that rings up quite regularly about lots of different issues, but that specific issue is never reported, that does really paint a picture. So it is really helpful to see the bigger picture. It also helps, for instance, where there may have been an opportunity to pick something up because a cleaner's been attending a communal area or a contractor, and there's a claim about something that you would expect someone visiting the property to have noticed. It gives us a bit of an idea of who are the relevant people to speak to here. Did they see something on those days? Can they recall? Would they have reported it if they did? So it goes beyond the actual cause of the accident and just provides this bigger picture. Now, on the same token, how far and how many of those repair and maintenance records do you provide? And I do say that there's no firm answer on this. Depending on how long the tenancy was, if it's within a particular property, it might be that the records for the whole of the tenancy are required. It will really come down to the specifics of the case, and you should be given some guidance in terms of we need the records for X date to Y date, and not just necessarily around the date of the accident. There will be a period of time that needs to be considered. Sometimes that'll be much longer. It could be, as I said, the whole of the tenancy. Sometimes it'll be a period of time. Beyond that, you might have complaints and contact records contained in a separate document. They're also really important. So that could be CRM notes, contact records, complaints records. And we'll come on to how they're recorded, but Those records are really important because they generally will supplement those maintenance and repair records as well. Again, copies of any formal complaints that are made and investigations into the same, and the complaints responses that have been provided. From experience, they normally are perhaps logged within any contact and CRM records, but the actual responses might not be. They're separate documents that are held elsewhere. Equally, if there's any communications to and from the Housing Ombudsman in respect of that property or that particular issue, that's really useful information to be able to provide early doors as well. Equally, inspection records and logs. So this is particularly where a claim might relate to a communal area or the estate. If you're undertaking estate inspections or inspections of communal areas and you've got records to support that, then they should be provided as well. And finally, any photographs of the potentially alleged defect or the area generally. These could even be photographs perhaps within void inspections or other inspections related to other issues that perhaps show the state of a property at a particular time. It's surprising how you can piece together information as to whether something was in existence at point A or whether it wasn't, and it can really help build a picture in regards to the claim as well. I've already said to avoid screenshots of records. Please do send the original documents. If you're taking a screenshot of any of these documents, you're creating a new document, and that original document is still disclosable. So it is just worthwhile providing the original document. We can always take screenshots later on if we need to particularly emphasize a particular part of that document, but please do provide the originals. I said as well, I'd cover how you perhaps call documents and save them. Naming convention seems to be a big bugbear. You will all call one document different names. So for instance, I already said about contact records. Some of you will save them in one document and have one rolling document that includes all contact from, say, a tenant. Some of you will call them CRM records. Some of you will call them complaints records. Some of them will be held in an Excel spreadsheet. Some will be held elsewhere. There is obviously different names that you will call them, and all documents, you might call them estate logs, estate inspections, walked inspections. You will know best what they're called. So if you are asked to provide something and you think that we just don't have those documents, pick up the phone and just clarify exactly what the document is that you're being asked to provide, because it might just be that you're calling them something different. And that is something that we see. There is no sort of universal naming for these documents, and that's absolutely fine. That's what you call them. It's more just understanding exactly what it is. Equally, if you're asked to provide a list of documents, please do just respond in regards to all of the documents that you're asked to provide. So if you don't have something, please just say, we don't have that, or say, for instance, a good example would be complaints. Can you provide us with complaints records for X period? You've looked and there aren't any. Instead of just not providing them, just add a line in saying, we've looked for complaint records, there were no complaints, because that allows us to understand that you've done a search and there aren't any, rather than it just being information that's absent. Now, on this slide, obviously, I've set out a number of documents that I consider generally should be provided across all housing claims. That's not an exhaustive list. There could be other documents that could also be provided depending on the specific nature of the case. So they could include, for instance, void inspections, tenancy sign-up documents, stock condition surveys, plans, stock transfer documentation, documentation relating to a housing conditions claim, if, for instance, an injury and illness claim is made subsequently, and there's been a previous housing conditions claim that has been settled or perhaps even repudiated. Gas or electrical safety certificates, and perhaps even correspondence or communications with the tenants in regards to access issues, if there's been issues there as well. So it's very hard to provide an exhaustive list, but hopefully you can see from that what documents generally will always be needed, and that there are some nuances depending on the type of the case as well. So why are these needed? Why are they important? Well, in order to defend or repudiate a claim, the organisation will need to establish that reasonable systems were in place, whether that be in respect of repairs and maintenance or inspection. We need to be able to demonstrate that as the landlord or occupier, you've acted reasonably. So that's being able to demonstrate everything that's going on the ground. Key issues that generally are subject to housing claims are notice of a particular defect or issue, or perhaps lack of, timings of any repairs and maintenance, whether that's in a demised property, a communal area, or on the estate generally, inspections and inspection regimes as may be necessary. So documents need to be able to demonstrate what's done. How does our system work? What do we do on a day-to-day basis? We say we do inspections, right? What are we doing there? How can we show that? So if we are inspecting our estates routinely, how often are we doing those? Do we have the documents to show that inspections are done? What systems are in place? Do we have any standard operating procedures that set out what our staff are doing on the ground when they're doing those inspections? Can we evidence with any documents what we say is being done? If we're looking at issues that have been perhaps reported, so most accidents will be to do with a defect, whether that's outside or inside a property. So has it been reported? What was reported? Who reported it? When was it reported? Do we have the documents to piece together what that chronology is? If a matter wasn't reported, was there an opportunity for us to have noted it? Was that perhaps a void inspection or attendance at a communal area by a cleaner or a contractor? If it was reported, how was it responded to? What action was taken, if any, and when? These are all the issues that we need to demonstrate. So if we've got documentation to back that up, that helps answer all of those questions. And what that allows us to do is provide that early decision making as to whether this is a claim to potentially fight or whether we think it's one to settle. Now, witness evidence, which will come later in the disclosure, can provide a really useful narrative around the documents, but the documents really ought to be able to demonstrate a clear chronology of events, with the witness being able to just add that narrative as to this is what the documents show and this is where it's shown. So just quickly on timescales, I said I'd cover this earlier. So this is just really for you to understand why you're being asked for documents early on and the timeframes involved. They're not just days and numbers that have been plucked out the air. So ultimately, documents should be provided to your insurer or panel solicitor as soon as practicably possible. The following deadlines apply pre-actions. This is when the claim is first made. So if the claim is submitted by way of a claims notification form, the response time is 30 days for a public liability claim and 40 days for an employer's liability claim. So really quite a tight timescale. If the claim's been submitted by a letter of claim, then it's 3 months from that letter of claim. And then in housing conditions claims, it will be 20 working days of receipt. That's actually deemed really 22 days. So 22 days from the date of the letter of claim. And you'll be able to provide those documents that we dealt with earlier on in the session that are set out in that pre-action protocol. And then you do get further time to respond on liability. And that's either responding at that time, or if you need further time, 20 days after receipt of an expert's report. So the timeframes are really, really quite short. Now, there is an opportunity to extend those if necessary, but I would say that that needs to be something that's avoided if at all possible. There will naturally be reasons that you do need to try and have a little bit more time. But I think being able to understand what those documents are that you need, you can start gathering those when the insurer is provided with the letter of claim or CNF. So you've already sort of started that process already to make it much easier to comply with those deadlines from the off. So some top tips to tie up what we've gone through. What I've done here is I've listed my top tips, having spoken to a number of colleagues, both within Waitmans and some of the clients that I work with as well, as to what they really find helps them repudiate claims from a disclosure and documentation point of view. And I think the gold standard and the first and foremost has to be record keeping. I really can't stress that enough. It is incredibly frustrating when you've got a case and we know that you are undertaking, say, estate inspections. And I've used this example a lot. We know those inspections are happening, but there are just no documents to back that up. I know it's another piece of paperwork for your staff to complete and for them to be logged somewhere, but actually being able to demonstrate that something has taken place is absolutely critical. A case with no documentation is often a case that can't be fought. So to be able to fight claims and repudiate them, keeping those records from day one and really being able to demonstrate what you're doing on the ground, how systems are working, how things are reported, and what's happening is really, really important. So that record keeping is the absolute number one. Knowing your records, it's surprising how many queries we raise. I can be really nitpicky. If any of you have had the opportunity to deal with claims with me before, where I will get repairs and maintenance records and whiz off lots of questions to you about what's in there that could be relevant. So, you know, this entry says that this was reported on X date. When was it repaired? Who was it repaired by? What date was that? So you being able to know your records and where to find that information is really, really useful. Being able to just understand them and be able to navigate them rather than just kind of passing them off to the insurers as well. So I would stress, just know what information is in there and what that looks like. Equally, knowing your policies and systems. Now, the organisations obviously that you're working in are going to be vast, and it's not necessarily going to be possible for you to know what every team and department is doing. But having a good idea where to find that information or who to go to and what your policies and procedures are in those key issues where claims arise. So inspections, repairs, maintenance, reasonable adjustments. And those really are the key policies that you need to be aware of. Just know where they are, what they say. Do they refer to all the documents in there? So does the policy say that we're doing inspections and they're recorded? Do you know what that is? Do you know where that information is? Providing complete records. So this is something I've already said, not screenshots, not records that you think are relevant. There is a real fine line between you providing everything for people to wade through, but complete documents are really, really useful. It helps be able to make sure that there are no gaps there. And certainly from a claims process, what happens sometimes is you provide what you think is relevant, and there's bits of documentation that have been removed or entries within repair records that have been taken out for being deemed not relevant to the case. And actually what happens later on is the complete record is provided and there's lots of information in there that paints a slightly different picture and can alter the strategy of a case as well. So providing those complete records from the outset is really, really important. Being able to explain your documents, this follows into knowing your records, be able to explain what they say, or if you can't do that, know someone that can. If the records say something has been completed, be able to evidence what was completed, what was done, when it was done and by who. It might be that that's not all contained in the information you provide, but know where that information is and be able to provide it as well. Understanding what the claim is about. I do think this is a really important factor as well, and actually probably is my number 2 under record keeping. I think it's really important for you to understand exactly what the claim is. So this is beyond the accident circumstances and what actually has happened, but what is it they're alleging? Understanding what the duty is and actually what we're trying to prove. It's the same analogy that I have with witnesses, and we ask someone to be a witness and they initially will say to me, but I didn't witness that accident. I don't know if I can help. And actually, we're not looking for material witnesses as to someone that witnessed the accident, but someone that could be a witness to policies, procedures, inspections. And I think the same applies here when you're providing disclosure. What is it that's being alleged? What is the duty that we're saying we haven't breached? And how do we prove that? I think that really helps in terms of that documentation gathering. Being able to provide a complete story at the start of a claim, not being piecemeal and not providing evidence later on. If we can provide a full story of what's happened, even if it's not the best story, it's better to have that from the beginning than it be provided later on. If early decisions can be made, it is cost saving to be able to do so. And that doesn't mean that every claim will need to be settled, but those that should be settled, if they can be settled earlier, can be done more cheaply than if they do at a later stage, especially if litigation has commenced. And finally, a holistic view. Being able to look at the claim as a whole and not just focus on the accident or any particular issues, or if it's a difficult tenant or a difficult customer, being able to just take a step back and look at the claim holistically. And finally, complaints and claims. So slightly different from the disclosure issue, but I do know that this can be really tricky for people to understand and sometimes difficult to identify the difference between a claim and a complaint. So a complaint is usually to seek answers about what went wrong and why. It's a formal expression of dissatisfaction. And the purpose of a complaint is usually to seek something like an apology or be told what's being done to prevent an issue from occurring again. And the real important point here is that it's an internal process. A claim, on the other hand, is when someone believes that they're entitled to payment or compensation and demands the same. So that's the legal process. Now, sometimes it's very, very obvious from communications that you receive as to whether it is a complaint or it is a claim. Obviously, complaints will be dealt with internally in your own process and not by the insurers, whereas a claim should be referred to them for them to pick up and handle within your policy. So I think the key considerations for you to ask in terms of, is this a complaint or is this a claim, is what is it we are being told? Is someone referring to an accident or health-related issues? Are they just complaining that something hasn't been done? Are they not happy with something? And what is the end result that they are seeking? Is it an apology? Is it a change in policy? Is it for repairs to be undertaken or finalised? Or are they setting out really starkly that they're after compensation? It can be really difficult sometimes to tell the difference, especially when customers are writing the complaints themselves. Sometimes it can be quite hard to navigate through those. And I've certainly seen a lot like that myself, where I have to sort of go back and reread it multiple times to really understand the crux of what it is that they're trying to ask for or complain about. If in doubt, what I would say is ask your insurer contact, or if you've got a really good relationship with the solicitors that deal with your claims, I'm sure they wouldn't have any issue you picking up the phone to them. But if in doubt, ask. Worst case scenario is that you've asked, you're told it's a complaint, and that you don't consider it a claim at this stage. You therefore deal with it with your internal policies. And if a claim does come to light at a later stage, the insurer's on notice of it and that it's already been logged, just in case that does happen. As I said, some are more straightforward than others, but hopefully that'll just give you some insight in terms of the difference between the two, because I know it can be tricky sometimes. So conscious of the time and that there might be some Q&As and that there's only about 7 minutes or so left, I'm going to hand back over to Esther, and I'd be happy to answer any Q&As when we get to that point as well.
Thank you so much, Rachel. Such an informative session. Really, really good. Just a quick message from me, just to highlight, we really do value your feedback on these sessions. So there's a couple of options to give us feedback. One, the QR code you see in front of you. So pop your phone up against the QR code with your camera on, and we'll also pop a survey link in the chat as well. So a couple of options for you to give feedback on today's session, which we do value. Dan, Lisa, over to you to open a Q&A, please.
Yeah, hi, good afternoon, everyone. So we've just had a couple of questions come up, obviously, throughout the session. So a common theme that we've had is about information being entered directly onto a database, or documents that are created completely electronically, and a screenshot basically being only the only document available. Is this okay, and how do we proceed in that case if there isn't actually a standalone document per se?
I mean, it's quite a tricky one. If the only option is obviously a screenshot, then that will have to suffice. I do commonly see it where there's screenshots taken of, say, repair records, but they are ultimately in a document that can be pulled into an Excel spreadsheet. Obviously, if they are contained in a document that can't be extracted or downloaded, then the best version of how you can provide those. But just with an explanation as to that's why there's a screenshot, because actually when we ask the questions, it's quite clear sometimes that someone just didn't know how to extract the documents, or there was another alternative. So just an explanation behind that, if that is the case. That's what I'd say on that.
No problem, thank you. And there's just one we had obviously from earlier on as well, is what happens if we provide disclosure of documents to the insurer, but then other documents come to light at a later stage?
So as I said earlier, the duty of disclosure continues through the life of a case, and people are expected to provide those documents throughout. So if something does come to light at a later stage, just send it over. And that's not uncommon for that to happen. It might be through discussions that are happening internally about a claim, Obviously, if we can get everything together early doors, that's the best position. But if stuff does come to light later on, just forward it over with any information that's needed as to where that's come from, why it's come to light, and that can be dealt with then.
Cool. Thank you. And would we usually be given a copy of the form that was illustrated within the presentation to complete throughout the claim?
No, so that disclosure list is the legal document that we provide during litigation. There's no, you can actually Google it and you can see that documentation. It's generally completed by the solicitors when court proceedings are issued, so there wouldn't be any need for you to complete that through the life of a claim. But it's a good idea to maybe be aware of what's on there, so you can kind of understand what the duty is and how the documents are split out. What we do have some guidance notes that we send out with those documents that just provide some information to explain what that document is. And I think being aware of it is just helpful, rather than it being sort of a rolling document to complete through the life of it.
Cool. Thank you, Rachel. And yeah, just obviously the remaining questions, so probably one for you, Esther, but just about availability of the slides and the recording of the session following concluding today.
Yeah, we will be sharing the recording afterwards, Dan. Thanks.
Right. Yeah, we've got no more questions.
Okay, brilliant. Well, that just brings me to close the event today. So again, a massive thank you to yourself, Rachel, for joining us and taking us through such a detailed and hot topic. So massive thank you from us. And for all that joined today as well, thank you for your time. Conscious that it's we're all busy, and taking an hour out of your time can be pressurised at times as well, but a massive thank you for taking that time and joining us today. The recording will be available at the end, but if you've got any questions at all, please just come to us. We're here to help and partner with you. Otherwise, that just leaves me to say have a good afternoon, and again, thanks for joining us.